So there are some big developments right now that we have to talk about when it comes to suppressors and short-barreled rifles. Across the nation, the debate has taken a turn, and we are looking at a moment where nearly a century of restrictions is being directly challenged. 15 states have stepped up to support lawsuits aimed at dismantling what is left of the National Firearms Act's control, and at the same time, the Supreme Court has shown interest in petitions that go right to the heart of short-barreled rifle regulations. This is not background noise. These are real signals that the ground beneath the NFA is shaking. To understand why this is so significant, it helps to look back. The National Firearms Act was passed in 1934. Its central tool was a $200 tax on items like machine guns, suppressors, short-barreled shotguns, and short-barreled rifles. At the height of the Great Depression, $200 was a staggering sum. In today's terms, it would be several $1,000s. That price tag was not about raising revenue. It was designed to stop ordinary people from acquiring these items. Congress wanted deterrence, and it got it. The law functioned less like a neutral tax and more like a prohibition shutting down civilian ownership by making it financially impossible. Courts upheld the law because it was framed as a tax measure under Article 1 of the Constitution. The theory was that Congress had the power to impose taxes, and the NFA was simply an exercise of that authority. That premise carried for decades. Judges and commentators repeated it as if it were unshakable. The government could not say openly that it was banning these firearms, but it could regulate them through the taxing power, and that was enough to satisfy the courts. Fast forward almost 90 years. Gun rights advocates worked for years to push legislation that would finally lift these restrictions. The Hearing Protection Act sought to remove suppressors from the NFA, while the Short Act was aimed at SBRs. The vision was straightforward: treat these items like ordinary firearms and end the paperwork maze. Supporters saw their best chance to fold those measures into a broader bill. That vehicle became H.R. 1, nicknamed the One Big Beautiful Bill. The legislation passed and the president signed it, but not everything made it through. What happened inside the Senate mattered more than many realized. The parliamentarian of the Senate, an unelected rules referee, invoked the Byrd Rule. That rule limits what can be included in a reconciliation bill to provisions directly tied to budget or revenue. The outright removal of suppressors and SBRs from the NFA, the parliamentarian decided, did not qualify. So that language was struck. What remained was a different outcome. The tax itself was reduced. The infamous $200 fee was set to $0. It was not the full repeal that advocates wanted, but it was still a major change. On the surface, this looked like a symbolic victory. No more paying the $200 tax when filing the paperwork. But legally, it was seismic. The NFA was always justified as a tax law. If there is no tax, then the justification evaporates. What you have left is a regulatory structure standing on air. That is why lawsuits quickly followed. Advocates seized on the moment to argue that the law no longer had any constitutional basis. Without a tax, there is no taxing power. Without a taxing power, there is no NFA as we have known it. Predictably, the opposition rushed in. Senator Chris Murphy put forward an amendment to a defense spending bill to push the tax not just back to $200, but up to $4,709 per stamp. That number was meant to reflect the inflation-adjusted value of the original 1934 fee. The point was obvious: restore the deterrent effect and bring the law back to what it once was. Whether such an amendment could pass is doubtful, but it shows how determined opponents are to fight back against the zero-tax shift. On the other side, gun rights organizations were not content to celebrate quietly. They mobilized. Groups like Gun Owners of America, the Firearms Regulatory Accountability Coalition, Silencer Shop, Palmetto State, Armory and Silencer Co. filed lawsuits aimed directly at the ATF. Their argument is simple. The NFA's foundation was the tax. That tax is gone. Congress cannot enforce the rest of the requirements without constitutional authority. Plaintiffs are asking courts to declare the law invalid as it applies to suppressors and SBRs, and to stop the ATF from enforcing those parts altogether. And it was not just organizations. States lined up too. Texas, Alaska, Georgia, Idaho, Indiana, Kansas, Louisiana, Montana, North Dakota, Oklahoma, South Carolina, South Dakota, Utah, West Virginia, and Wyoming, 15 states in total, joined the fight. That is an extraordinary coalition. These states are not just offering rhetorical support. They are officially backing a lawsuit that seeks to dismantle a federal gun law that has stood since the 1930s. It is a bold move that underscores how far the battle has advanced. The lawsuits were filed in the Northern District of Texas. That was no accident. This district has become a central front in recent fights over gun regulations. Judges like Reed O'Connor and Matthew Kaczmarek have issued rulings against federal overreach in cases dealing with pistol braces, forced reset triggers, and unfinished receivers. Advocates know this court has a history of looking skeptically at aggressive regulatory claims by the ATF. Choosing this venue was a strategic decision to maximize the chance of an early favorable ruling. Even as those cases work their way through, attention is shifting to the Supreme Court. 2 petitions. Rush and Robinson are asking the justices to strike down the NFA's restrictions on SBRs under the Second Amendment. In a significant development, the court directed the Department of Justice to file responses after the Trump DOJ initially waived them. That kind of order is not routine. It shows the justices are paying attention. When the Supreme Court signals interest in an issue, it usually means they see unresolved constitutional questions. If they grant review, the outcome could overshadow the district cases entirely and set a nationwide precedent. So here is where things stand. The tax has been cut to zero, undermining the legal premise of the NFA. Democrats are scrambling to restore it. Gun rights organizations in 15 states are suing to dismantle the remaining restrictions. Those suits are in a district known for strong rulings in favor of the Second Amendment. And at the same time, the Supreme Court is circling, showing interest in reviewing whether these restrictions can survive under the Constitution at all. Decades of assumptions are being tested, and the future of suppressors and SBRs is suddenly uncertain in a way that seemed impossible only a few years ago. The lawsuits now before the courts challenge the very foundation of the NFA. Plaintiffs argue that the act was upheld only as a tax law. For 90 years, the $200 fee was the constitutional hook. When the One Big Beautiful Bill reduced that amount to zero, the foundation collapsed. What remains is a set of regulations without taxing authority to support them. Congress cannot regulate simply because it wants to. It must rely on enumerated powers, and when the tax is gone, so is the justification. That is why these lawsuits matter. The complaints stress that although registration and transfer requirements remain, they no longer serve any valid purpose. People are still asked to file paperwork, submit fingerprints, and wait months for approval, but none of it connects back to a tax that no longer exists. Plaintiffs want courts to strike down these requirements and block the ATF from enforcing them. If granted, suppressors and SBRs would be removed from the NFA's grip once and for all. Filing in the Northern District of Texas was deliberate. This court has produced key rulings against federal gun regulations in recent years. Judges there have looked critically at ATF attempts to stretch its authority, whether in cases involving unfinished receivers, pistol braces, or forced reset triggers. Plaintiffs know this venue is not afraid to check aggressive federal action. A victory would set the stage for appeals and could shape the path to the Supreme Court. And the Supreme Court is already watching. 2 cases, Rush and Robinson, directly target the NFA's restrictions on short-barreled rifles. Both argue the law violates the Second Amendment. Initially, the Trump DOJ waived its right to respond, but the court ordered briefs anyway. That is not routine. It shows the justices see a live constitutional issue. If they grant review, the outcome could reset firearms regulation nationwide. A ruling in favor of the challengers would overshadow the district court fights and establish binding precedent across all states. Meanwhile, the Department of Justice and the ATF are trying to defend the law. In some filings, they have admitted that suppressors qualify as arms under the Second Amendment. Yet they portray the NFA as a shall-issue permitting system. Their line is that because most applications are eventually approved, the law works like the licensing structures the court said were acceptable in the Bruin decision. In their telling, the NFA is not a ban, just a process. Critics reject that framing. The NFA process is nothing like ordinary licensing. It is slow, invasive, and discouraging. For decades, the $200 tax reinforced that burden, keeping ownership out of reach for ordinary people. Even now, with the tax cut to zero, fingerprints registration and federal approval remain. Plaintiffs argue this shows the law was always about suppression, not a neutral permit, and once the tax disappears, there is nothing left to save it. Gun control advocates are pushing back just as hard. They argue that deregulating suppressors and SBRs threatens public safety. They warn suppressors could conceal gunfire and that SBRs are easier to hide. These claims are not new, but they are being amplified to rally opposition. The fight is legal and political, and neither side intends to back down. What happens next depends on timing. If the Supreme Court grants review in Rush or Robinson, lower courts may pause. That would not be a setback. It would mean the justices are prepared to decide the issue directly. If they decline, the Texas cases will continue, and victories there could still send the matter back to the court later. Either way, momentum is real. Pressure is building for a decisive answer. The DOJ's approach adds uncertainty. At times, the government has sounded sympathetic to Second Amendment claims, acknowledging that NFA items are arms. Yet in other contexts, especially in machine gun cases before the Fifth Circuit, it has defended the NFA's constitutionality forcefully. That inconsistency makes it hard to predict how aggressively they will fight. Outcomes could move faster or stall depending on strategy. Still, the zero tax ensures that the constitutional question will not disappear. What is clear is that the NFA is no longer untouchable. For almost 90 years, it stood as a fixture of federal firearms law, rarely challenged and always upheld. But with the tax gone, the assumptions that protected it have vanished. 15 states are now backing lawsuits to strike it down. National organizations are investing heavily in litigation. Courts already skeptical of federal overreach are preparing to weigh in again. And the Supreme Court is signaling readiness to step into the debate. For Second Amendment supporters, this is the moment they have been waiting for. The opposition is organized, but the legal and political landscape has shifted. The argument is straightforward. The NFA was built on a tax. That tax is gone. And when the foundation is gone, the structure cannot stand. Whether the breakthrough comes from Texas, the Fifth Circuit, or the Supreme Court, the fight is here, and it is moving quickly. This is not a minor dispute. It is a constitutional clash that will decide how far Congress can go and how much the government can intrude on the right to keep and bear arms. The future of suppressors and short-barreled rifles is being determined right now in real courtrooms by real judges with consequences that will echo for decades. This nation was built by people who insisted on their rights, and it will endure only if that insistence continues.